നമ്മൾ എടുക്കുന്ന ടോപ്പിക് is trial of warrant cases by magistrate. This is the topic. This is mentioned under chapter 19 of the Criminal Procedure Code, which is mentioned under section 238 to 250. So this chapter has three parts: part A, capital A, part B, and part C. Part A deals with section 238 to 243. Part B deals with section 244 to 247. And the part C deals with the section 248 to 250. And part A deals with cases instituted on a police report. And part B deals with cases instituted otherwise than on a police report. And the part C is conclusion of trial. So the title എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ the trial of warrant cases by magistrates. So the first point is what is trial, and trial doesn't define in the Criminal Procedure Code, but different kinds of trial has been mentioned under chapter 18, chapter 19, chapter 20 and 21 of the Criminal Procedure Code. And chapter 18 deals with the trial before court of session. Chapter 19 deals with the trial of warrant cases by magistrate, and chapter 20 deals with the trial of warrant cases, trial of summons cases by magistrate, and the chapter 21 deals with the summary trial. So these are the four important kinds of trial specifically mentioned under chapter 18 to chapter 21 of CRPC. പക്ഷേ ഈ മുൻസിഫ് മജിസ്ട്രേറ്റ് എക്സാമിനേഷന് ഈ ട്രയൽ ബിഫോർ കോർട്ട് ഓഫ് സെഷൻ അത്ര റിലവൻ്റ് അല്ല. അതുകൊണ്ടാണ് നമ്മൾ ഈ ട്രയൽ ഓഫ് വാറന്റ് കേസസിലേക്ക് വന്നത്. So now we are dealing with the chapter 19, that is trial of warrant cases by magistrates. So first question is whether the term trial is defined under the Act. No. The definition clause is there in section 2, but in the definition clause, the term trial doesn't define. And then the next question is warrant case. Whether the term warrant case is defined. Yes, it is defined under section 2x. 2 small x define the term warrant cases. Warrant case means a case which is punishable more than 2 years. An offense which is punishable more than 2 years. And what is the definition of offense? The term offense is defined under section 2n of the Act, the Criminal Procedure Code. And it is also defined under section 40 of Indian Penal Code. So this chapter is completely deals with the trial of warrant case. And what is the meaning of warrant case? Warrant case is defined under section 2x. As per section 2x, what is a warrant case? A warrant case where the offense is punishable more than 2 years. Then the question is the magistrate, who is the presiding officer of who is a magistrate. So the term magistrate is not defined under the provisions of the Act, but at the same time, magistrate means the presiding officer of the magistrate court. And chapter 2 of the Criminal Procedure Code deals with the constitution of criminal courts and its officers, which has been mentioned under section 6 to section 25 capital A, where when you look into the hierarchy of court, there are a set of courts which are mentioned in this section, especially section 10, 11, 12, 13. All these sections are dealing with the magistrate court, and the magistrate courts are broadly classified into 3. they are the second class judicial magistrate, first class judicial magistrate, and chief judicial magistrate court. And in the metropolitan cities, there are two kinds of metropolitan magistrate courts are there: the metropolitan magistrate court and the chief metropolitan magistrate court. And the presiding officer of all these courts, the magistrate courts, are called the magistrates. So the magistrates are competent to try a case as specifically mentioned in this chapter, chapter 18. So who is a magistrate? The term magistrate is not defined under the Act, but the magistrate is a presiding officer of the magistrate court is called a magistrate. For example, presiding officer of second class judicial magistrate court is called a magistrate, first class judicial magistrate court is called a magistrate, and the chief judicial magistrate court is called magistrate. And also the in the metropolitan cities, metropolitan magistrate court is there, and the metropolitan magistrate court is equivalent to the first class judicial magistrate court, and the chief metropolitan magistrate court is equivalent to chief judicial magistrate court. So this is the most important point that is important as far as the trial before the trial of warrant cases magistrate is concerned. അപ്പൊ ഇതിലേക്ക് വരുമ്പോൾ നമ്മൾ ഓർത്തിരിക്കേണ്ട ഒരു പോയിന്റ് എന്ന് വെച്ച് കഴിഞ്ഞാല് there are two important persons are there in a criminal trial. Number one is a person who committed an offense, and the second one is the person who is an affected person. And the affected person means a person who is injured by the act or omission of the party, another person, which is punishable by law. So the person who commits any offense is called accused. But the most important point is that the term accused is not defined in the criminal procedure code. The term accused is not defined under the criminal procedure code, but the term victim is defined under section 2WA of the criminal procedure code. The victim is defined under section 2WA of the criminal procedure code. So you please refer section 2WA of the criminal procedure code. So number one, accused; second, victim. So accused means a person who committed an offense, and the victim means an affected person. The legal representatives of the victim is also come under the purview of the victim in the definition as laid down in section 2WA of the criminal procedure code. Then the question is, the presiding officer, the presiding officer of the court is called a magistrate. Then the victim, as you know, that every crime is committed against the state. Therefore, the victim is supported by the prosecution lawyer. So prosecution lawyer in Parayumbo, very important point is ividate prosecution lawyer aaranu vechayinal the assistant public prosecutor. And the assistant public prosecutor is an officer of the court appointed under section 25 of the criminal procedure code. And the term assistant public prosecutor doesn't define under the criminal procedure code, but the appointment qualification and the other important points related to the assistant public prosecutor has mentioned under section 25 of the criminal procedure code. And the public prosecutor is specifically mentioned under section 2, and the appointment of public prosecutor has mentioned under section 24 of that. So the public prosecutor means a prosecutor who is handling cases in sessions court, and the assistant public prosecutor means an officer who is handling cases in the magistrate court for the state. And his main duty is to protect the important different rights of the victim. And what about the accused? Accused is actually represented by a lawyer. അത് രണ്ട് രീതിയാണ്. നമ്പർ 1, അക്യൂസ്ഡ് ഒരു സഫീഷ്യൻ്റ് ആയിട്ട് ഒരു എക്കണോമിക്കലി സ്റ്റേബിൾ ആയിട്ടുള്ള ആളാണെങ്കിൽ ഇറ്റ് ഈസ് ഹീസ് ഡ്യൂട്ടി ടു അപ്പോയിന്റ് എ ലോയർ. If he is a person who has any disability which is mentioned under the Legal Service Authorities Act, he is eligible for legal service. And also, this is specifically mentioned under Section 304 of the Criminal Procedure Code. It is because it is so held in number of judgments, including the Hussainara cartoon case, and in number of Sugdas versus Union of India, in number of judgments, that right to legal aid is a fundamental right. In criminal cases, in civil cases, in all other matters, right to legal aid is a fundamental right for eligible candidates, those candidates who are specifically mentioned under the Legal Service Authorities Act 1986. So it is a fundamental right. It is also a constitutional right, which has been mentioned under Article 39, capital A of the Constitution, which has incorporated in the 42nd Amendment in 1976. And it is also a very important legal right mentioned under the Legal Service Authorities Act 1986, and also as far as the criminal cases are concerned, it is specifically mentioned under Section 304 of the Criminal Procedure Code. അപ്പോൾ ഇതാണ് നിങ്ങളുടെ മനസ്സിൽ ഓർമ്മ വരേണ്ടത്. ഈ ട്രയല് ആയിട്ട് ബന്ധപ്പെട്ട് നിങ്ങൾക്ക് ഒരു കോർട്ട് ഓർമ്മ വരണം. സോ ദ മജിസ്ട്രേറ്റ് ഓർമ്മ വരണം. ആൻഡ് ആ മജിസ്ട്രേറ്റ് ആവാൻ വേണ്ടിയിട്ടാണ് ഇപ്പോൾ നിങ്ങൾ പഠിച്ചുകൊണ്ടിരിക്കുന്നത്. സോ ദ പ്രിസൈഡിംഗ് ഓഫീസർ ഓഫ് ദ മജിസ്ട്രേറ്റ് കോർട്ട് ഈസ് കോൾഡ് മജിസ്ട്രേറ്റ്, ആൻഡ് ദാറ്റ് മജിസ്ട്രേറ്റ് ഈസ് അപ്പോയിന്റഡ് ബൈ ദ ഹൈക്കോർട്ട്, which is specifically mentioned under Chapter 2. And these magistrates are appointed by the High Court because of independence of judiciary, because judiciary is independent. So every appointment of judiciary is the monopoly of the judiciary as per the Constitution, and which is mentioned under different articles of the Constitution. And the independence of judiciary is one of the basic structure of Indian Constitution. It was so held in number of judgments, including Indira Nehru Gandhi versus Narayanan, and also in Chandrakumar versus Union of India case. So that was the one of the major reason why the magistrates are appointed by the High Court, and it is not appointed by the State Public Service Commission. So this is something which is very important. But at the same time, the public prosecutor, the assistant public prosecutors are appointed by the state. And it is appointed in Kerala. It is this appointment is the appointment of the public prosecutor, assistant public prosecutor, is completely vested in the hands of Kerala Public Service Commission. അപ്പോൾ ഇതെല്ലാം നിങ്ങൾക്ക് മനസ്സിലാക്കണം. നമ്പർ 1 is an accused, who is an accused, who is a victim, and who is an assistant public prosecutor, who is a magistrate, and what is the meaning of a magistrate court, and who is a lawyer, and when the accused is eligible for legal service. ഇത്രയും കാര്യങ്ങൾ ഇതിൽ ഇമ്പോർട്ടൻ്റ് ആണ്. പിന്നെ നമ്മൾ ഇതിലേക്ക് വരുന്ന സമയത്ത് നമ്മൾ മനസ്സിലാക്കേണ്ട കാര്യം, so that is what is the meaning of the title, Trial of Warrant Cases by Magistrates. ഇതിലേക്ക് വരുമ്പോൾ you know the warrant cases are cases punishable more than 2 years, and cases instituted on a police report. രണ്ട് രീതിയിലാണ് കേസ് ഈ കോടതിയിൽ വരുന്നത്. ഈ കോടതിയിൽ കേസ് വരുന്നത് രണ്ട് തരത്തിലുള്ള കേസസ് ആണ് വരുന്നത്. ഫോർ ദാറ്റ് പർപ്പസ് the offenses are broadly classified into 6. For example, the cognizable offense, non-cognizable offense, bailable offense, non-bailable offense, and compoundable offense and non-compoundable offense. So these are the different categories of offenses for the purpose of investigation and trial. It is so specifically classified in the Criminal Procedure Code, especially in the Schedule 1 and the Section 310D, because what are cognizable offense and what are non-cognizable offense, what are bailable offense and what are non-bailable offense, and are mentioned under first schedule of Criminal Procedure Code. But at the same time, what are compoundable offense and what are not is specifically mentioned under section 320 of Criminal Procedure Code. So idana adinte classification, offense in the classification. Offense is also defined. What is the meaning of the offense is defined in section 2N. So രണ്ട് തരത്തിലാണ് കേസ് കോടതിയിൽ വരുന്നത്. ഈ കേസസ് doesn't matter whether a particular offense is a cognizable or non-cognizable, bailable, non-bailable, compoundable and non-compoundable. It is instituted on the basis of a police report and by way of a complaint. There are two methods. ഇങ്ങനെ വരുന്ന കേസസ് ആണ് കോഗ്നിസൻസ് എടുക്കാൻ മജിസ്ട്രേറ്റിന് അധികാരമുണ്ട് എന്ന് ഇറ്റ് ഈസ് സ്പെസിഫിക്കലി മെൻഷൻ അണ്ടർ സെക്ഷൻ 190. അപ്പൊ ഈ മജിസ്ട്രേറ്റിന് കോഗ്നിസൻസ് എടുക്കാനായിട്ട് പറ്റുന്നത് 4 രീതിയിലാണ്. അത് വൺ ഈസ് ഓൺ ദ ബേസ് ഓഫ് കോഗ്നിസൻസ് കേസ് എടുക്കാൻ കഴിയുന്നത് 4 രീതിയിലാണ്. One is by way of police report and second one is by way of a complaint, or third one is by way of any information from any person or any information he directly received from any other source. ഇങ്ങനെ 4 രീതിയിലാണ് സെക്ഷൻ 190 അനുസരിച്ച് മജിസ്ട്രേറ്റിന് കോഗ്നിസൻസ് എടുക്കാൻ പറ്റുന്നത്. സോ ദ വേർഡ് ഈസ് വെരി വെരി ഇമ്പോർട്ടൻറ്റ്, ഈസ് കോഗ്നിസൻസ്. അപ്പോൾ the different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional